Most political discourse focuses on the daily headlines. We spend our energy debating symptoms, personalities, and the chaotic noise of the news cycle. Understanding how power actually operates requires looking past the smoke of modern scandals to examine the blueprints of the house itself. We have to analyze the foundations and the strict jurisdictional limits of authority. Every system of governance depends on one structural question. Does government create law, or is government bound by law? The common law tradition provides a single, unambiguous answer in the form of a binding maxim. Government is subject to the law because the law makes the government. Law exists first. Government is created later, entirely as an instrument subject to that prior law. Reversing this order of operations transforms the structure of governance into an engine for arbitrary force. The Declaration of Independence establishes this exact sequence. By citing the laws of nature and of nature's God, the text clarifies that power does not originate with kings, parliaments, or majorities. It flows downward from a source higher than any human institution. Because power originates in nature, individuals do not receive their rights from society. Your rights to your body, your labor, your property, and your will exist because you exist. They are pre-political. Since individuals already possess these rights, government exists for the narrow purpose of securing and protecting them. That is its sole legitimate end. Protection is strictly defensive. It presumes something already belongs to you and restrains others from taking it. This is distinct from provision, which actively expands authority to distribute resources. A governing body that moves from defending existing rights to actively providing benefits abandons its legal end. It exercises force outside its defined boundaries, resulting in usurpation. This architecture is an inverted pyramid. Original authority sits at the top, the laws of nature. Directly below is the individual. Every person receives inherent defensive rights from nature. The third tier, the people, does not generate new authority. It simply aggregates existing individual defensive rights. Frederick Bastiat defined law specifically through this lens. Law, he wrote, is the collective organization of the individual's right to lawful defense. This establishes a mathematical constraint. A collective force acquires no greater authority than the individuals who compose it. If an individual lacks the right to take a neighbor's property without consent, the collective lacks that right as well. 0 multiplied by any number is still 0. John Locke codified this principle in his 2 treatises of government. He noted that whenever a legislature attempts to take or destroy the property of the people, they put themselves into a state of war with the population, and all obligation to obey is voided. Moving further down the pyramid, we reach the 4th tier, the state. In the American structure, the state is the politic body. At the narrowest point sits government. It is merely the administrative machinery created by the state. It is an agent and a trustee. Because power is held by the individual and aggregated by the people, government possesses 0 inherent authority. Every action it takes must trace back to strict downward delegation. This structure eliminates the concept of inherent police power, the idea that governments possess a broad authority to regulate behavior for the general welfare. Delegation cannot exceed ownership. No individual possesses the right to invade a peaceful neighbor's property for social improvement. Therefore, the collective government cannot acquire that power either. The Constitution exists as a cage, built to confine pre-existing collective force. Thomas Paine noted that government, even in its best state, is a necessary evil. He understood that concentrated force is dangerous and requires unyielding confinement. In the 1795 case, Van Horn's lessee v. Dorrance, the court established that the Constitution prescribes a strict legal orbit. Any legislative act outside that orbit is not merely mistaken, it is absolutely void. Acts outside the legal orbit strip the creature of its governing character. It quickly becomes mere unbridled force. Imagine a security guard hired with narrow instructions. Stand at the door and protect your life savings from invasion. At first, the vault is safe. But mission drift begins when the guard starts reorganizing the cash for efficiency, shifting from strictly protecting your property to managing it. Soon, the guard hands over a stack of your bills to a struggling friend, substituting sympathy for authority. Eventually, the vault is treated as a community fund. Protection is replaced by benefit distribution. The guard later formalizes the redistribution with a written policy. He uses administrative procedure to sanitize the act. In the final stage, the guard increases his own wage to manage these new programs. The owner now feeds the creature hired to guard the vault. Government behavior follows this pattern. A creature rarely roars when it leaves the cage. It uses spreadsheets and compassion to step beyond its boundaries. Once the patterns of provision and plunder are established, property is no longer secure. Good intentions do not change the structural reality. Stopping the creature requires an emotionless structural test. This checklist identifies if a government act is law or injury. First, does the act conform to the rule of right? If a policy authorizes what would otherwise be theft, no statute can convert that injury into law. Second, does it secure a pre-existing right? If the act distributes a new benefit rather than securing existing boundaries, it fails. Third, does it avoid crossing the theft line? If an individual cannot lawfully extract property from a neighbor, the collective cannot vote to do it either. Fourth, is the authority to act explicitly delegated in writing? Silence does not grant power. Fifth, does it remain strictly inside the constitutional cage? If it operates in the space reserved for liberty, authority evaporates. This is a pass-fail test. A single no to any of these questions means the act fails structurally. It is void. This test frustrates ambition and denies exceptions. If the cage bends for a favored policy, the bars become suggestions and the creature runs free. The oath of office is not a ceremony. It is the strict jurisdictional condition of authority. Article 6 of the Constitution makes this explicit. All officers are legally bound to support the document.
Without the oath, there is no lawful office, only the occupation of a seat. An oath binds conduct, not intent. Claiming good intentions does not preserve authority. Only strict conformity to the limits of the cage preserves authority. This means silence is an active breach. If an official watches the creature step outside the bounds of the Constitution and does nothing to stop it, they become an accomplice to the escape. Breaching the oath terminates the condition of authority. The creature is now unbound. The Constitution is the cage, the oath is the lock, but the people remain the keeper. Memorize the checklist. Step outside the noise of politics and begin diagnosing the structural integrity of the laws around you. Once you see the architecture, you cannot unsee it.